So, Renato, can President Biden order SEAL Team 6 to assassinate Trump now?
Well, it is complicated. I'm Renato Mariotti. I'm a former federal prosecutor, a practicing lawyer, and a legal analyst.
And I'm Asha Rangappa. I'm a former FBI agent. I teach national security law at Yale University, and I'm a legal contributor for ABC News.
And we're here to help you understand topics that can't be boiled down into a soundbite or a tweet. Asha, I gotta say, if any topic cannot be boiled down into a soundbite, it is this decision, which is just unbelievable. This Trump
horrifying
decision. Yeah, it's really something. I have to say,
I was not expecting this. Were you?
No, you know what I was expecting? So I'll just say, if you read the decision, and we'll have to walk through this in more detail, there was a separate concurrence by Justice Barrett.
Yeah.
And that was more along the lines of where I thought things might look. It turns out she was not the fifth vote. She was the sixth vote. And so accordingly, her opinions on this didn't matter, but they were more measured than the majority opinion.
Yeah.
So let's talk about what's in that majority opinion.
Oh, boy. Yeah. So I think the best way to summarize this opinion is that the majority purports to be engaging in a separation of powers analysis. In other words, they are looking at how the balance of power among the different branches play out if you allow for prosecutions of the president for kind of ordinarily applicable laws. And where they go with, framing the problem in this way is they say Article 2 of the Constitution confers certain powers exclusively to the executive branch. And, they specify the things that if you go into Article 2, you can, you see like making treaties and appointing ambassadors and all of these things. And they say that in having that exclusive and preclusive authority, that means that the other branches cannot, under any circumstances, encroach on those powers. And that means that he cannot be criminally prosecuted for anything falling within that scope. We'll get back to kind of some more details on that in a second. Then they say, but, not everything is spelled out. There's also powers that overlap with Congress. There are certain shared, in the Youngstown Steel case from 1952, Justice Jackson called this the zone of twilight, that there's like certain, an area where executive power overlaps with Congress to various degrees, and it's not really clear where one branch starts and another ends. And so there is sort of an outer perimeter of official authority that some things may fall under that may not be explicitly mentioned or may not necessarily even be exclusive or preclusive. And what the court says is that for those things, the president gets at least presumptive immunity, meaning...
What does that mean? Yeah, I was going to say that.
Yeah, it's not clear. So presumptive immunity is that he's immune unless the government rebuts the presumption that prosecuting him for these acts would interfere with the functions and authority of the executive branch. So bookmark that with footnote number 2. We'll come back to that. Then they say, and then there's, a whole slew of things that fall outside of this whole realm, and there is no immunity for that. And so there is this very, in my opinion, deceptively simple framework that the court presents. And I think that there are two nuances here that really upend the whole thing and make it almost like it's kind of a sham in a way. And one of those things, and I don't know how you feel about this, Renato, is that what they say is that when you're looking at anything that is either clearly core conduct, Article 2 acts or powers or things that are in, the outer perimeter in trying to determine whether this is an official act. You can't look at the motive that is behind it. And to me, this is really weird because what they're doing is saying there's no such thing as an unlawful act that you do, with the cloak of official authority. And to me, that's the most dangerous thing.
Right. So that's a really good point. And by the way, I'm just going to say to everybody, Asha and I have not discussed our views in advance. I've actually started a new job and I've been focused on other things. We just read the opinion separately. And it's interesting because I would key on that as there's certain tells, I think, in the opinion. And that's one of them. Because there's all sorts of times, Asha, when you do things that in and of themselves aren't illegal, but your motive in doing so is what makes it illegal, right? I mean, you could break down anything. I mean, I in a closing argument one time talked about, well, in a bank robbery, it's not like writing a note is illegal, but if you write, give me all your money and you hand it to the teller, then it is, right? Or putting a ski mask on in and of itself isn't illegal. But all sorts of things, wiring money isn't illegal. You could always find ways of describing something as that could that is a crime in ways that are legal. And here, it's definitely a dangerous thing to say. I think one of the more dangerous pieces of the opinion is where they say essentially the president can direct the attorney general to do whatever, right? Of essentially, investigate my enemies, don't investigate my friends. And that is essentially something that cannot be even examined, the president's motive is to that.
Yes. And to get to the SEAL Team 6 example, one of the most expansive Article 2 authorities that the president has is the commander-in-chief authority. And, what the court is saying is, and this is something that I teach in my national security law class. We talk about drone strikes and we talk about the killing of Anwar al-Awlaki, who was an American citizen, and Obama ordered a drone strike on him. It was not reviewed by a court. I don't think it would be. But part of the legal justification that the Justice Department put out it was this very elaborate legal justification about this is a senior operational leader of Al-Qaeda and they pose a threat to the United States. And this is preemptive self-defense. In other words, there's all of these public authority justifications, right? And I think most people would agree that in kind of waging a war against, an enemy that is seeking to harm the United States, that the president has probably pretty expansive commander-in-chief authority. I think most people would not want the president to order a drone strike on someone who tweeted something mean about him. And they would find that qualitatively different. But I personally read this opinion as saying, if he has the authority to order the drone strike, you really can't inquire into why he did it or what the purpose is.
Yeah, or if the president says, I don't want you to investigate what happened in Watergate, that's fine, right? The president can presumably order the attorney general to shut down an investigation of alleged wrongdoing that could lead back to him. So it's very, that's very interesting. I would say very much a tell. Here's another piece that's interesting to me. You can't introduce that as evidence of something else. So, and that's a real tell there, right? Because what I think you could almost see.
Wait, let's pause there so you explain exactly what you're referring to. You cannot introduce an official act as evidence to prove anything like motive or intent, even if the crime is something that is completely non-official.
Right. So let's say, for example, hypothetically, the president murders someone. He has a secret affair and murders his paramour. Totally not an official act. I think everyone agrees there's nothing official about that. But then the president walks back to the White House, makes a phone call to the attorney general and says, do not have that. I hear there's been calls to the FBI. You need to shut down the FBI's investigation of this person's death. That act, not only can that not be, totally immune for that obstruction of justice in that scenario, but also that can't be used as evidence of the president's intent. In other words, to show the fact that
guilt,
right? The fact that the president was the murderer in this scenario. It's really, and I almost think what's happening here is you have justices who are thinking about how this is going to actually play out in this prosecution.
Yes.
And we can talk more about that in a minute, and why I think that may have animated this. But I think that is one of the most interesting aspects of this opinion.
Yes. And that was the piece that Justice Barrett really took issue with. And I think it's useful to use an analogy in the First Amendment context. So generally speaking, you cannot be prosecuted criminally for, let's say, your religious beliefs. Okay? You have a First Amendment right to believe whatever you want, even to believe really abhorrent beliefs as a part of your religious dogma. However, if you go, let's take somebody who's a white Christian nationalist. Okay, that is their theology. If they go and shoot up a black church, they can't be prosecuted for their beliefs, but their beliefs can be used to demonstrate why they targeted those specific people. In fact, it can be used to enhance the sentence they receive, because that would qualify as a hate crime. So you can see how, we have managed to balance even things that we have tremendous protections, to and give wide latitude and buffers for, that we still allow that kind of expression or activity to be used in other ways to maintain the rule of law. And that, I think, is here that completely collapses. And I was just thinking, Renato, because you have prosecuted these cases before, let's just take the bribery context. The definition of bribery is that you exchange an official act for a thing of value. Am I right?
That is true. In fact, that's the core definition of it, really.
So if the president accepts a bribe in exchange for an official act, how would you actually prove the bribery charge?
Yeah, it's very interesting. It depends, I guess, what zone the official act is in, right? Is it a pardon? Or is it something more in the penumbra of official acts? I will say that even in that, let's just hypothetically say that the president is taking, a bribe in order to make a pronouncement of some kind. Let's put aside pardons and some of these more core things. Even in that context, the fact that there's a presumption, use that term early on, this presumption. And what that is going to essentially mean is the presumption is that the president can't be prosecuted for taking money in exchange for doing something, right? That's an official act. And for example, buy your own official state dinner or whatever. I don't know. By paying me privately for that. In that circumstance, you actually have to essentially the prosecutor would actually have to go through all the steps of not only bringing that prosecution, but then on the front end, essentially convincing a judge that they have the case to make against the president, and that it should overcome that presumption. It puts just a ton of barriers and obstacles in the way of any sort of criminal prosecution of the president, and essentially makes it so that, absent the most extreme circumstances, you're not going to see a president prosecuted for anything.
Yeah. So when you're talking, I'm thinking, what if Vladimir Putin offered a future President Trump $1 billion to deploy SEAL Team 6, military, special forces, whatever, to assassinate Volodymyr Zelensky? That involves his core commander-in-chief authority. It involves exclusive Article 2 authority to negotiate with heads of state. There's literally nothing, according to the court, that's all immunized conduct. Maybe the taking the money is bad, but it'd be like listening to a phone call where you only hear one end and you can't hear what the other one's saying.
That's why I think the evidentiary part of it is the most head scratcher piece of it.
I agree.
And to Justice Barrett's credit, she did not go along with that. I will note that she comes from a different background. than a lot of the other justices that were in the majority, because the other justices in the majority, were involved in like the Reagan administration or something where there or the George W. Bush administration, where there was a lot of focus on the expansion of federal power. She's more or less a law professor who's looking at this from a different perspective. But nonetheless, I think I would feel differently about the opinion if hers was the majority, because I think it would be more defensible. But even as it is, even with her opinion, it's still highly problematic. And I just, the way I think of it, Asha, what came to my first reading of this opinion, it reminded me a lot of the Bush versus Gore opinion, in that there was some big bad thing that was going to happen, which is the uncertainty of the presidential election in the United States. A majority on the court, and an ideological majority, right? There was a 5-4 in that case, came up with sort of a once in a lifetime precedent that they said you cannot use in any other circumstance. And sort of, decided that issue. I feel like here there is another big bad out there. I use big bad. It's sort of like a comic book term. Like you've got Thanos is coming with the gauntlet or whatever. You have this other big bad, like, oh no, the election is going to get decided in a courtroom, and the choice of the people is going to be taken away, and it's going to undermine faith in our judicial system, whatever they're telling you, whatever the justices were concerned about. Or that perhaps the president would be paralyzed by fear of being prosecuted, or whatever their concerns are. And they've created a system to essentially make it as difficult as possible for Jack Smith to proceed with this prosecution and get anywhere with it before the election. And I think it's very hard for me to understand some of these, the specific pieces of this opinion, like the evidentiary one, through a different lens than that. That's essentially what came to mind.
I agree with you, but I'll say that the difference between this and Bush v. Gore is that in Bush v. Gore, they at least said, this only applies to this specific case, and we're not claiming that this has any kind of precedential value. And here, they were very explicitly creating a rule for the ages, which really contravenes a basic principle of, Supreme Court jurisprudence, which is to not make big sweeping pronouncements. Especially constitutional pronouncements about the scope of authority of a branch, unless, it's absolutely necessary. And I think that was one of Justice Barrett's critiques of it, is we don't need to go this far. Like, we can cabin this looking at what is, in fact, in front of us. And I think the fact that they felt like they needed to create this sweeping rule, it's really hard to see how this benefits anyone but Trump. Because, in other words, it only benefits the bad actor, is in my view. So, I think you could argue, well, this protects Biden, if Trump wins. No, it doesn't. Because all Trump would have to do is gin up a fabricated, evidence and investigation on quote unquote non-official acts, Burisma something something. Joe Biden was trafficking children. I mean, you could make up anything and decide to prosecute him for it and make up evidence. And there's literally nothing that would be a deterrent to doing that.
I guess the way I would look at it, I agree with you that in this much. I mean, I think that there's no question in my mind that this is a precedent for the ages, and they didn't need to go there. I think you could understand, I think there are legitimate concerns about having presidents facing fears of prosecution. I could see the reason why you might want to limit that to a certain extent. I could even see on the front end saying, look, before prosecution can go forward, maybe there needs to be some look at it by a judge in the front end to see whether there's something to it, because the mere accusation alone could potentially, and going through trial, could be that could be burdensome on a president. I could see certain concerns like that. But I think here, and then this is why I said, like, when you look at the evidentiary piece of it and the presumption, and so you put it all together, what I'm seeing here is a rule that makes it just very difficult to have a prosecution of a president for acts during his presidency at all. And there, I agree. The real concern there is there's no limiting principle there. Very difficult. And yes, it's true that technically the government could overcome the presumption solely with evidence that had nothing to do with an official act, potentially. But it's challenging. And what I think that, just to sort of kind of transition a little bit to how Jack Smith's reacting to this, because this is tied into I think the analysis that you and I are having here about the implications, Asha, is I think if you're Jack Smith looking at this, I mean, my initial reaction to this, because I was trying to figure that out. I figured we'd want to talk about it in the podcast. Like, people want to know, what does this mean for the January 6th case? And my original reaction to this is, okay, if I'm Jack Smith, I am going to narrow my case. I did this as a prosecutor. I filed something that just made up called an intent to narrow proof. And I just filed it basically to say, I'm only going to proceed on one thing, not three things. Essentially is what I did in that case. Here, could he say, I'm going to only proceed on these 12 paragraphs or this one count or this or that? The problem with what the court did here is that they've essentially said, because they anticipated this, is they said all this other stuff that you're not going to proceed on, you can't use as evidence, even indirectly for some other reason or for some other purpose. So you're going to have this narrow telescope view into what Trump did. Yeah, and then they also made their own factual findings to say that tweets are essentially official acts because they're the bully pulpit of the president, and made all these sort of specific factual things to essentially make it so that Judge Chutkan will have to go through and on a detailed one-by-one basis to determine whether each one of even his tweets is an official act. And then she's got to analyze, according to the Supreme Court, whether all of that on its own is sufficient to merit a prosecution, because you can't just allow Jack Smith to go on half of his indictment or a third of his indictment or a fourth of his indictment. They're basically creating so many steps and so many hoops to jump through that you may never get to the finish line.
Yes, and I'll go even further. I think it's really circular, right, in some ways, because in other words, determining, you can't use motive to determine whether something is official or not official, right? So imagine that Trump says, I was taking care that the laws were faithfully executed. I believe that the Electoral Vote Act has to be executed properly. I have, as the president and chief law enforcement person in the country, I need to make sure that our voting laws and the integrity of our national elections are sound. And so, my tweets, everything I did was in furtherance of this, including and up to, talking to state legislators or whatever. So the only way you can really show that that's not true is if you can point to the fact that people were telling him constantly that he lost, and that he acknowledged that he had lost, that he knew he lost, but he was trying to find a way to overturn the will of the people regardless. Unfortunately, those conversations are all happening with his advisors who are around him. And those are shielded from being used to show. So in other words, he can, I think, I mean, I don't even know where you go with any of these charges if you can't show like a very basic piece of this whole coup plot, which is that Trump knew that he lost and he was trying to overturn the election. Like, I think that state of mind is so key to understanding why those tweets were not official acts, why these phone calls to, state legislatures were not official acts, why his speech on the ellipse was not an official act. I don't know. To me, I just don't see how you can get to one without the other.
Well, I think that's why you and I are so focused on the evidentiary piece here. And that's, I think you and I are kind of arriving at a similar spot here. So there's certain, just to break down the conduct, right? the Supreme Court makes clear that they can't proceed on this whole Jeffrey Clark, let's utilize the Justice Department to spread lies and falsehoods, piece, which is interesting. So that is out entirely. Can't use it as evidence, totally immune for everything he does there. The conversations with Pence are like shrug, that's up in Chutkan's lap, but the reality is I think the court says enough to put that in doubt. But
correct. I think that's
probably
off
the table, even though they move as they move their lips. So they write certain things that say that it's an open question, but I don't think it really is. So that's out. So, and then I think, and then they even say the tweets and all of that stuff, the incitement of the rioters and insurrectionists, that is, questionable. And then what do you make of, so then the question is, what about all these fake electors? And what about all of that? So can that stand on its own? And is that, now he's going to claim what you just said, that is an official act. She's going to have to do an evidentiary, she being Judge Chutkan's going to have to do an evidentiary hearing on all that. But without all this other context, without anything else about his state of mind, is the mere fact of that scheme enough to get a conviction? Isn't that what we're left with?
Yeah. Yeah, I don't know what you're left with, to be honest. And let's just, by the way, that's not where the inquiry ends either. So this is, I think, the most nefarious part of the immunity opinion is you have, the absolute immunity, you have no immunity, then you have this middle gray area of presumptive immunity and whether the prosecution has overcome the presumption. Yeah, Chutkan can do this whole evidentiary hearing. She can come up with decisions on it. Guess what? Those get appealed, and guess who decides those eventually?
Yeah.
This same court. So, people have said that this opinion makes the president a king. Kind of. It really makes 6 justices on the Supreme Court kings. That's what I think, because they're the ones who are going to determine what falls on one side of the line and what falls on the other. And I have not read anything, maybe the core exclusive authorities, because at least you can point to maybe some textual words in Article 2. But the gray area, the meat of this is going to be in that outer perimeter, presumptive immunity. Did the government meet the standard? Which side does it fall? And they are going to be the ones playing umpire on that question.
Yeah, or particularly, some of this stuff like private, essentially private statements about falsehood, essentially falsehoods, statements about falsehoods on a private messaging platform. That being an official act is a bit of a head scratcher. Particularly, it's interesting because the Justice Department, at times, there's been inconsistent positions taken. Let's just put it this way: inconsistent judicial findings regarding what's an official act and what's not an official act regarding Trump's statements on Twitter. I will say that, from my perspective, I'm not surprised that courts want to take more authority for themselves. Okay, that is as old as our Supreme Court itself, from Marbury versus Madison, where that's just Supreme Court justices want to take more power for themselves. But I will say, creating a ruling that is that can create such devastating consequences, can be abused in certain ways, is very dangerous. It's a very dangerous thing for our country. And that I am very concerned about. Asha, I'm very concerned about how Trump, if he's reelected, could potentially use the military in some of the ways you suggested to do things that are truly not only evil, but unconstitutional, but totally, under this opinion, be outside the review of any court. And if that happens, there may not be a Supreme Court to consider the issue by the time the whole thing is over.
Yeah. And I think that it drives home the point that, the only thing that now keeps us from falling into some crazy abyss where the president is, sending the military to assassinate people is really the good faith and self-policing and morals and principles of the person who holds the office. I mean, listen, technically speaking, President Biden has all of this expansive immunity today. Right?
Technically speaking.
I mean, he could, order Merrick Garland to shred all the documents relating to Hunter Biden's prosecution. He could, tell him to fire the special. I mean, he could be doing all of these things, literally. And he's apparently it's fine. Like, it's not that he's going to pay any consequences for it. He won't, because he considers himself a steward of the office of the presidency, that he is constrained by certain, I don't know, moral norms and government norms, like things that you do and you don't do. So that's what I kind of get to, is that the only person this benefits is a bad actor, because a good faith actor is not actually going to be in need of this kind of immunity. And by the way, on the military point, I just want to throw out there, and this is a question for another day, this really throws into, like, what do people who follow orders, where do they stand now when they're given an unlawful order or an illegal order? I mean, Mark Hertling tweeted that it now puts the burden of kind of making those determinations. I guess they've always been there, but knowing that, like, they are the ones who are held accountable, not the person to whom they report.
Yeah, I guess they're only held accountable if they potentially do the right thing, and then the president doesn't like that and orders the attorney general to investigate them. They're not held accountable if the president pardons them.
Correct.
I think, Liz, as I alluded to earlier, I do think I could see there being genuine concerns about having a president under investigation by some random DA somewhere in every administration going forward due to whatever polarization or so on. But I think this goes so far beyond what one would need to create a protection there that it's hard to explain in any way other than ensuring that nothing happens regarding this specific prosecution. And I will say, just as, people often ask for predictions and this and that, here's one where I'm going to be, I don't say I'm a quote optimist, unquote. I'm never that type of person here, but I do think if I predict what Jack Smith's going to do, I think Jack Smith's going to try to find some way forward. I think he is going to push forward as fast as he can with whatever he thinks he has left here. And he's going to let Judge Chutkan and ultimately courts above her make whatever decision they're going to make, but he's going to continue pushing forward, and he's not going to stop doing so. The issue is just going to be how narrow of a read does he have left after this decision in terms of getting to a conviction, and then can he get anywhere before the election is underway? And my prediction on that is no. I don't think he will be able to do that.
Nope. People need to wake up. Democracy is on the ballot. So we are excited to bring onto our podcast this week Kim Wehle, who is a professor at University of Baltimore Law School. She is a colleague of mine at ABC News, so you can catch her if you tune into ABC News Live, especially in Supreme Court season. I'm sure she's going to be on a lot the coming weeks. And I especially wanted to bring you on, Kim, because, and she's also a fellow Substacker. That's what I was going to say, too. We both, your Substack is...
It's called Simple Politics.
Simple Politics with Kim Willie. Yes.
Yeah.
It's one of my recommended Substacks on my page. So we'll include a link to that as well in our show description. But the reason I wanted to have you on is that I know that you wrote about the recent Chevron decision and then the decision that came out after that about the time period in which people can bring challenges. And this is like an upending of basically all of admin law. And I know that you have been teaching this for years. And I really thought that we could benefit, even though I'm sure Renato and I, could read the case and, talk about, this is overturning 40 years of precedent. I feel like you can really get in the weeds of what this means, because in many ways, as much as we have been kind of preoccupied and captivated by the January 6th cases, these cases really impact kind of our day-to-day lives in a much more direct way than maybe anything else this term. I don't know how you feel about that, but so where do we start? Like, if you said that you have been teaching this for many years, and Chevron was a major, like a central case, obviously, for your class. So,
well, I think we can start with basic first principles. And I say this because it's a second or third year course and students don't know these basics. So if listeners already know this, they can tune out. But the three-part system of government are three branches. The legislature makes laws, and laws are prospective and they apply to everybody. Thou shalt not, give stink eye on the subway, right? It's for everyone prospectively. Judges,
everyone except former president.
Thank you. Exactly. I don't know. Yeah, I think that's probably a big one too. Maybe even bigger, but that's probably for another day. Judges look at things retroactively for individual people, right? Joe Schmendrick does something to Jane Doe and needs to be made whole, trashes her car, right? So that's the primary distinction. And then presidents are the top law enforcement officers, the top prosecutor, law, police officer, essentially. Those are the three things. So Congress makes laws, presidents enforce the laws, but primarily around the time of the New Deal, after the stock market crash and the Great Depression, FDR, Franklin Delano Roosevelt, and his Democratic-controlled Congress decided we need to do something to fix the economy, and they started creating what are known as executive branch agencies. So it's anything with the word department of or commission in it. They're all over Washington. The president's cabinet is, Secretary of Labor, Secretary of Commerce. Those are all agencies. And in theory, they're supposed to just be enforcing the law, like the FBI. You know this well, obviously, Asha. But Congress said, listen, we can't do everything. We don't have all the expertise. So we're going to actually, when we create these agencies, we're going to give them the power to issue what are called regulations. Regulations are laws that fill in the blanks of statutes that are kind of vague. And the Supreme Court in the 1930s started striking down some of these statutes, saying, wait a minute, only Congress can do this. Congress has lawmaking power. Agencies answer to the president. They're supposed to just be enforcing the law. These are unconstitutional. The court pushed back on that, ironically, I think, given what's happened this week and the talks about what to do at the Supreme Court, when FDR threatened to pack the court. He said, listen, if you're going to start striking down my New Deal stuff, I'm going to add justices and we're going to outnumber you and you're going to become obsolete. And the justices pulled back and stopped striking down acts of Congress that created agencies that had this power. So we talk a lot. People say, I hate people will say, critics of regulations will say we need less regulation. Of course, President Reagan famously ran on deregulation. Bureaucrats are terrible. That's the kind of mythology around it, frankly. But the reason that we have agencies is that we've got political gridlock in Congress. They don't pass laws if they have to do every detail. They don't have expertise. They're not experts in food and drug safety. They're not experts in how to store nuclear fuel. They're not experts in aviation to make sure planes don't crash into each other. There's hundreds and hundreds of these regulatory agencies. And the third reason that we have agencies is if you let courts do it instead, courts fill in the blanks of ambiguous language, you're going to have different rulings in different parts of the country. You're going to have the Ninth Circuit rule one way, you're going to have the 11th Circuit in Florida rule another way, and you're going to have a company that wants to comply with the law, not knowing what the law is in one place or another. So Chevron was a case in which the Supreme Court said, okay, if Congress says agencies can regulate and agencies act within what Congress said they can do, we're not going to second guess Congress. We're going to defer to how Congress decides to regulate because they're experts, because Congress picked them to actually fill in the ambiguities, and because that way everybody knows they'll probably be upheld in court and the entire country can have one set of rules. The Supreme Court in the Loper-Bright case reversed Chevron and frankly took the power to itself, said, we are now going to be the ultimate regulators in the country. We're going to decide, we're going to kind of set aside what the agencies do, And even though we're not experts any more than Congress, us, the Supreme Court, are going to decide really what regulations should say.
So thank you for that. And I really love like the temporal perspective of the different branches. I think that's a really useful way to think about it, because this is sort of like agencies working in real time to essentially make the laws work, practically speaking.
Right. And that temporal distinction is something the Supreme Court has actually held in cases in the early 20th century. That my characterization of laws are prospective, apply to the world, cases are retroactive, apply to individuals, that the Supreme Court has actually made that very clear in case law.
Just to kind of bring this home for our listeners, I'm thinking this, like, let's just kind of do a concrete example. Like, let's take the Federal Aviation Administration. Congress says you have to create, planes have to fly safely, or pilots have to have adequate sleep, or something like that, maybe, right? And the regulations will actually spell out, for example, how that is going to work in practice.
Yeah, so use the word safely. You use the word safely. Planes must drive safely. So Congress will say, okay, we've set that standard. We want experts in aviation to explain what safely means. So then you'll have regulations that will then have specifics on how to inspect the plane, what kind, all of that. You'll say, okay, we want aviation experts to define the word safely.
As opposed to Justice Thomas.
Correct.
Now, just to be clear, right, there will still be regulations. The difference is going to be the weight to which that we're going to have to give agencies interpretation of the law and those regulations.
That's correct. But Renato, I would say, let's put a footnote in that, because you're absolutely right. But remember, I said back in the 1930s, a conservative court started striking down these statutes saying, this is only Congress that can do it. There is energy on the Supreme Court, Justice Thomas primarily, to revive that doctrine. It's called the non-delegation doctrine. So I think it is possible with this court within our lifetime for the court to decide, actually, only Congress can make laws. Regulations are unconstitutional. But in this moment, what you're saying is right. What they've essentially said is, sure, regulators, go ahead and do it. We just might not like what you do. And so this is a power grab from regulators, but it's also a power grab from Congress, because Congress decided the agency should be doing this. And in a major area they're doing this is in environmental regulation, right? Where there was a case this term where essentially in the Clean Air Act, Congress said, listen, the states are close to each other. If one state is going to pollute the air and there's going to be downstream air pollution that goes from New York to New Jersey, New York needs to answer for itself. And so EPA did some regulation around that, decided there were some bad actor states that weren't complying with the Clean Air Act, the states went to the Supreme Court. The Supreme Court struck it down halted it on a preliminary injunction, didn't even wait to get to the merits. They said, listen, we don't like this. We're going to stop EPA in its tracks and side with these states. And the regulatory process takes years. So it's a real waste of taxpayer dollars to do it this way.
Yeah, I know. I hear what you're saying on that. I mean, I think as a practical matter, what's going to happen, if for right now, you're right that there may be future decisions. What's going to happen is regulators are going to promulgate regulations. People out there in the industry are going to potentially try to follow them. Some of them are going to potentially litigate against the agencies and spend, like you said, a massive amount of not only taxpayer dollars on one side, but their own dollars on another side. And there's going to be uncertainty. Now, will people be following those regulations? Many will, and for all sorts of reasons, right? Partly because it gives you a certain presumption that what you're doing is correct. But in the short run, I think there's going to be more litigation and more uncertainty, right? In the short run, and then who knows what could come from there.
And I think I think you're absolutely right. And so the question is the uncertainty, when you're doing your P&L statement and you're doing your projections, if you're a regulated entity, you're not going to know necessarily how things are going to shake out. I think it also creates some questions for regulators. Do we go through the process at all, knowing that we don't know? if in a couple of years the Supreme Court is going to say, no, we don't like what you did. And the court has already been doing that with another line of cases. It's calling the major questions doctrine. So this isn't a huge shift. It's just bigger. The major questions doctrine, where the court has essentially said maybe a year or two ago, there are just certain things that even if Congress gives the agency power to do it, we don't believe they really meant to do that. So we're not going to allow the agency's regulation to stand. So the bigger separation of powers problem with this is the Supreme Court is grabbing the power of the other two branches. The Supreme Court is becoming an imperial court, the bosses of the country, the kings and queens of the nation, because there's no accountability. And of course, we saw that also with the immunity decision.
Yeah, that's the rub, right? They're saying, oh, the executive branch can't be lawmakers, but they're essentially going to become policymakers themselves by how they interpret. So I'm just curious, Kim, so these are statutes that are affirmatively delegating authority to the agencies from Congress, and the court, like, it's not that there's a gap that Congress didn't speak on, that they are basically giving permission through the statute for the agencies to do this. Why is this different than other types of delegation?
You're absolutely correct. Chevron doesn't or did not apply if there was not a specific, what I call to my students, a handoff of the legislative baton by Congress. Congress has to say, we are giving the Department of Energy the specific regulatory authority to clarify what this kind of law needs to be for this industry. The Supreme Court has basically gone back to 1804, the landmark case in Marbury versus Madison, where the court basically said for itself, the court gets to decide ambiguity in the Constitution. That's not in the Constitution. We could have a regime today where the president interprets Article 2, legislator interprets Article 1. I mean, it's not obvious that it's the Supreme Court that does that, but they essentially said that is our core authority to interpret ambiguous language. Now, on the very heady administrative law professor blogs, the question comes up, to your point, Asha, okay, if what your job is to interpret what Congress said, and Congress said the agency gets to do this, shouldn't you just let the agency do it? I don't think that's what the court's saying. The court is that is, I think, the intellectually honest reading. I think what the court is essentially saying is, no, we're going to do it. And why do I say that? Because they've already been doing it with the major questions doctrine.
Yeah. And that came into play with Biden's loan forgiveness program, right?
It came up
that basically he was through the executive order. I mean, this is kind of another arena where the executive sort of makes law, right? They issue executive orders, and basically in the loan case, the student loan forgiveness case, they said, you're not acting in the scope of this delegated authority that Congress gave you. You've basically created a new statutory scheme.
Yeah, I mean, that might have been a little more traditional interpretation of statutes. And just to be clear, courts do this. The major questions doctrine came up, I think, most prominently with the cap and trade program that the Obama administration had created, and then Trump came in and killed it. And then Biden stayed with, the regulation's dead. The court took that case anyway. There probably wasn't even standing because it was a hypothetical program by EPA, and said, no. EPA is not meant to be doing this kind of impact on the environment. We're not going to let, even though the language is very broad, they're essentially saying, Congress, you need to go back and do the regulating. That's the major questions doctrine. But you're absolutely right. Sorry, my dogs are barking. But you're absolutely right. Just so listeners understand, if you take a statute from Congress and say it's 5 pages, you'll have 5,000 pages of regulations, right? So most of our world, most of our economy, the things that, when you go to the grocery store, you buy something, you get in the car, and how the emissions from your car and the safety mechanism, most of it's done by agencies. And now people will say, well, agencies are terrible. They're not elected. But they do answer to the president, and members of Congress are elected, and Congress can always change their authority, change the law that governs them. So they're a lot more democratically accountable than the Supreme Court justices, who are now in charge of regulation ultimately for the country. And to Renato's point, I just don't know how it's going to play out. But this gloom and doom scenario, sorry about my dog, this gloom and doom scenario on Chevron has been something that experts in this area have been deeply worried about for quite a while now. And it's been cited 18,000 times by lower court judges, more than Brown versus Board of Education and Roe versus Wade and all those other big cases combined.
Well, first of all, I just want to say we're very pro-dog. At least half of this podcast is pro-dog. Okay, the other half is pro-cat. So we're very pro-dog on this podcast. But I was just going to say, I mean, I think one of the things just to kind of help our listeners and viewers get their heads around this is I think you bring up a really good important point, Kim. What really the growth of the regulatory state is it's a way of responding to the fact that our world is increasingly complex. You need expertise. Now, there is an issue with them, right? It's not like anyone elected directly. Bureaucrats at the FDA or the FDIC or a number of other agencies, but we don't really have a better answer for that problem right now. And a lot of folks in the world, not just people who view these podcasts, but business owners and others, they actually need certainty and need to be able to know what the rules of the road are so that they can make decisions. And this, I think, definitely creates more uncertainty. It's going to create more litigation. So it's good for lawyers like me, but it's not necessarily something that's going to be helpful for people out there who are trying to, know in advance what the regulatory framework is going to be for themselves.
Well, and also the process is very laborious. There's a process called notice and comment. So it's actually a very inherently democratic process that regulations go through. I do it with my students. A regular person can file what's called a comment. You can say, this is the kind of law I want. You file it online on regulations.gov. You put your opinion in there. And under the statutory framework that controls how agencies operate, it's called the Administrative Procedure Act, they have to read your comments and take them into account. Members of Congress don't have to do that. I mean, if you're a big lobbyist, they'll take your call. If you're just an interested person, you might get a staffer, you might get nobody. And then there's very stringent judicial review standards for agencies. So I'm not that worried that they're out of control. I think it's really more, there's some concerns about too many laws and we don't like the laws and we want to be in charge of the laws. And that's what's, I think, happened by having this very conservative court, conservative in quotes, because it's quite radical, actually, conservative court in charge of regulation now across the country.
So let's turn to part two of this, to the stability piece, which is that after Loper-Bright last week, a Thursday or Friday, I think, the court handed down another opinion, which relates to the administrative state, which is about the time window you have in order to bring a challenge to these regulations. So it sounds like the window used to be 6 years from the date that the rule or regulation is promulgated, that, affected entities could come back and challenge it in court. And what the court has said now is that it's not 6 years from the time the rule is promulgated. It's 6 years from the time that an affected entity is harmed, which means that a rule that's been in effect for like 20 years, if I created a new business tomorrow and I'm suddenly affected by, whatever, the EPA regulations or FDA regulations or some health and safety standards, and I don't like it, I can now challenge it, even though it's been in effect for 2 decades and probably thousands of other businesses or entities have come to rely on that being a standard thing. Am I getting this right?
You're right. That's exactly what happened. And, the blogs and listservs are up in arms about that too, because of course this opens up a whole slew of regulation to challenge. The third thing the court did this term also has, I think, important implications. And that has to do with what are known as administrative law judges. So we have a certain number of federal judges. It's hard to get them through the Senate. The president appoints them. Agencies have their own judges. They're called ALJs. The Securities and Exchange Commission has them. Lots of agencies have them. The immigration services have them. These are judges that do the work of resolving disputes between individual parties and the agencies. And for the SEC, there were administrative law judges. There were also federal judges that challenges to alleged SEC violations could be brought to. And the court said that it's unconstitutional to use the administrative law judges. So that's going to put more pressure on the federal courts and potentially narrow the number of cases the SEC can bring for enforcement of the Securities Exchange Act. And I think it raises a big question. Okay, what other kinds of agency ALJs could now be unconstitutional?
And what was their reasoning? It was about jury.
The Seventh Amendment.
Yeah.
It was the Seventh Amendment. So the Seventh Amendment basically puts us back in our time machine and says, if in common law England, you had a right to a jury trial, you would get a right to a jury trial in 2024. So they essentially said SEC securities actions are similar to the kinds of things that were on the Jolly Shires of England way back when. I mean, and this is a well-established doctrine. This is not, this Seventh Amendment, and this is how the court looks at it. You really do go back in time. And they said essentially, okay, you have a Seventh Amendment right today. You can't give it to a non-Article III judge. The problem with it is there's a whole line of cases that carves out administrative law judges to resolve administrative agency disputes. The public rights doctrine, it's called. So the court expanded the Seventh Amendment in a way that had been pretty settled. And there are thousands and thousands of ALJs, and it's unclear, which of the agency actions are going to be like the things in common law England, and which will not. But here we have more litigation, more uncertainty, and potentially an opening to basically overturn some of these agency determinations that people have been relying on the theory that they're unconstitutional.
And is the end game here that it just basically, these agencies just come to a grinding halt, basically?
Well, they're going to have to shift, and I think their power and their influence is going to be narrower for sure. And, the fact that the Supreme Court is doing this as a matter of the Constitution, right, saying it's our constitutional power to interpret laws under Marbury. It's under the Seventh Amendment, you can't give it to ALJs. Under Article 2 of the Constitution, there's criminal immunity for presidents. When the Supreme Court makes these rulings under the Constitution itself, there's nothing that can be done about it other than a constitutional amendment or a new configuration on the court. Congress can't fix that. And I think from somebody who's been studying the separation of powers for a long time, this is the problem, this is the threat, is this expansion of power in the United States Supreme Court where there's no oversight. Like I tell people, non-lawyers, you could have a law, the law can say 35 miles an hour. We'll go 50 until there's a ticket in the mail because there's a machine in the bushes that takes a video of you going 50. The next time you drive down that street, you'll go 35. So it's the ticket for speeding. It's the accountability. It's the consequences that makes the law meaningful. And the problem with the Supreme Court right now, and the problem, in my view, with the immunity case, which I'm sure you've been talking about, is what's the ticket for speeding? What's the ticket for committing crimes in the White House using the massive office of official power, which is much greater than unofficial power? What's the ticket for speeding by the Supreme Court in contravention of established precedent and even the plain language of the Constitution? There aren't any. And James Madison famously said ambition needs to be made to counteract ambition. The idea being, you need to have consequences for violating rules or the rules become optional. And that's, I think, where we are. And we're going to see more of it out of the Supreme Court, and certainly more of it if Donald Trump gets a second term in office.
Kim, I know you have to go.
I
know you do. But you've got to tell us about your dogs before you go.
Okay. I will tell them I've got 2 Cavapoos, Charlie and Tiger. Charlie's 10 and Tiger's 4. He's my COVID dog. They're Cavalier King Charles Spaniel poodle mixes. And I shall also add my new book on the Pardon Power comes out September 2nd. Asha blurbed it for me and has taken a look at it. So hopefully we can come back and talk about that.
Yeah. Another great executive power that,
It popped up in the immunity case multiple times too.
It did.
It did.
Great.
Anyway, yeah, they're very cute, my dogs, even though I hope people can hear over their barking.
Thank you so much for joining us, Kim.
I enjoyed it. Thanks for having me.
Awesome.
Take care.
So, Renato, before we go, do you have any fun plans for what may be our last 4th of July celebration?
Well, I'm going to have a great week. I'm just, as I mentioned earlier, just started a new job. So I'm not traveling for this one. But my birthday is July 3rd. And my mom's birthday is July 5th.
Oh, wow.
So yes. So I'm spending all day with her, and we're doing, she is making food. My wife is just aghast that my mom wants to make food for this, but she loves that makes her feel happy. So she's doing all sorts of food and desserts, and we always have ribs on 4th of July. It's just we're meat eaters, so that's our thing. And I'm actually, for my birthday, we're going to this like fancy Indian restaurant called Indian in Chicago. That's like a Michelin star Indian restaurant.
Ooh.
So yeah, we're excited about that. We'll see what it is. Very fancy.
Ooh.
But I was like, let's try something different, like something totally unique. What about you? Are you doing anything fun?
So I am going to a big family reunion in Maryland.
Okay.
Yeah, and it's like
Maryland.
It's the 40th anniversary of our doing this kind of extended family reunion. So there's going to be even more people there. I'm taking my boyfriend for the first time. So this is like going to be his introduction to the clan. So, we're he'll be wearing Indian clothing and things like that. So
wow,
I know.
How does he feel about that?
I think he's fine. He's excited. For guys, it's pretty simple, right? It's just a kurta. It's like a long shirt,
Yeah.
But he has one semi-fancy one for one of the evenings that we got when we went to Jackson Heights. But otherwise, I think it's just kind of very simple, and they're pretty like comfortable. I think for guys, so it's like kind of like walking around in pajamas.
Aren't saris comfortable for women? Are they not comfortable?
It depends. I mean, saris for me are not comfortable. Like I am always worried that I'm going to have a wardrobe malfunction. And the other ones, I mean, they can, if they're very fancy, they can be very heavy. And I mean, you've seen them. There's like long skirt,
in the summer.
Yeah. So, I mean, but there are more casual things that are less onerous. But anyway, so Indian clothing, Indian food. I love 4th of July. I think it's one of my favorite holidays just because it's like, it's sunny and everybody's off and you get to go, I don't know, just hang out and spend time with people. And that's a fun time to have a birthday, I would think, like, because, you have a holiday and it's not like a Christmas or something like that where you get screwed out of getting gifts. So you still get your gifts, and B, where like the attention is almost where the holiday eclipses the birthday. I don't feel like that would happen on the 4th of July.
When I was a kid, I thought this was the coolest time to have a birthday because it was midpoint in the year. So I got maximum presents. Mm-hmm. That was the way I thought of it when I was like 6 years old or 8 years old, because my parents had 6 months to save for the next batch of presents. Which is perfect. And we got to do like fun stuff. We go to like water parks or, do something to like fun in the summer. We were off and it was a holiday.
Yeah. I feel like the only downside is maybe as a kid, you're not in school. So maybe all your friends aren't around or something like that.
Well, what I didn't like is everyone else, and when it was during the school year for their birthdays, they would get like cupcakes and everyone got to like we'd have a class period where we would talk about their birthday and no one got the summer birthdays got like all lumped together on one day and it was not the same.
Yeah. Well, happy birthday to you, and I hope you have a great and fun weekend.
You too.
MSW Media.